Good morning, friends. Today we will discuss Chapter 9 of Criminal Procedure Code, Provision 125 to 128. That chapter deals with the order for maintenance of wives, children, and parents. In this PPT, we will discuss about the who is having the right for the maintenance first of all, and second is against whom that person have a right. And then after we will discuss what are the procedure to be followed by the court while he is trying to maintain against the any person, and case laws regarding the right to maintenance of the women under the criminal procedure code, because this is very disputed topic regarding the women's right to maintenance from her husband. Then we will start. First of all, what the question may be asked in the interim examination, that is the under what circumstances a wife can get maintenance from her husband. Can this right be exercised by parents and legitimate children? Explain. Then this is the introduction. You can use this introduction in any question pertaining to this chapter. That is Dharmashastra have described the maintenance of wife, children, and parents, a moral duty of every person. Manusmriti in its chapter has confirmed this statement and also agreed to it that every person should maintain his wife, minor children, and parent even after performing 100 obligations. Law also prescribes such provision regarding the maintenance of such person, and this is provision belongs to the family law, Mohammedan law, and this is the Criminal Procedure Code 125 of CRPC. Then we will start first who is entitled for the maintenance, and the provision is 125 clause 1, and these are the five category. This person is entitled to get the maintenance from whom this will also be discussed. Wife, if the wife is unable to maintain herself, that means the wife can get the maintenance from her husband. So wife means opposite who? Husband. This is the minor child. Minor child where the terms used child, that means against whom? Her or his father or parents. The minor child, that means legitimate or illegitimate minor child is entitled to get the maintenance whether married or not, and but that child unable to maintain herself. This is the minor child. Absolutely no doubt he is or she is unable to maintain herself. But it might be possible that if certain earning have to that child, that means he is not entitled to get the maintenance. Like that, if any share or any mortgage property or any lease property he is earning from that property monthly, then that person is capable to maintain himself or herself, then he is not entitled to get the maintenance from her parents. Third is the unmarried daughter. Unmarried daughter means legitimate daughter or illegitimate daughter, no problem, but not being a married daughter. So this is unmarried daughter. It is doesn't matter that she got the age of majority or not. Only the criteria is that she is unable to maintain herself or him herself, and second is that she is not a married, and fourth is that incapable child, the child who is attained the age of majority, where such child by reason of incapability cannot maintain themselves. So what does mean by incapable child? Either he is unsound mind person or handicapped person, that he cannot maintain himself or themselves, then he is entitled to get the maintenance from their parents. And lastly is that father and mother. Father and mother is also entitled to get the maintenance from their wards, from their child. So unable to maintain herself or himself, what the matter is that, and this is the case laws. We will discuss later on. Then five categories there: wife, minor child, unmarried daughter, incapable child, and father and son. These are the persons who is entitled to get the maintenance from their opposite. Then after we will move to the next slide, and this is what are the grounds must be fulfilled by the person who is claiming for the maintenance. That is, the petitioner is unable to maintain himself first of all. Second is against whom is going to file the petition. That person must have the sufficient means, and respondent neglects or refuses to maintain. That point must have to proved by the petitioner. What are that? That the petitioner is unable to maintain himself, and the respondent is having the sufficient means, and we asked to the respondent for maintain him, but he has refused. Then we are talking about the married female child. Married female child, no doubt, when we are talking about the who is the natural guardian, then we can see that the natural guardian of the married daughter is her husband is the natural guardian. Then after, her husband is the firstly responsible to maintain his wife. Then if he but there are two conditions when the married daughter is entitled to get the maintenance from their parents. What is that? That's if she is minor, and second is that her husband is not possessed of sufficient means. Even the daughter got the married, then that means her husband is the responsible person to maintain herself. But where she is minor and her husband is not having sufficient means, then the married daughter can claim against her parents. Then after, where the petition has been filed and all three ingredients has been proved by the petitioner, then after, a magistrate of a first class may order such person to make a monthly allowances for the maintenance of his wife or such child, father or mother, as such monthly rate as such magistrate think fit, and to pay the same to such person as a magistrate may from time to time direct. That means what the amount is ordered by the magistrate then may be altered time to time. If the circumstances has been changed, the amount of the maintenance may be also changed. That means the magistrate first class is the competent magistrate where the petitioner may move for the maintenance, and they can file a petition against the respondent, and the magistrate may order if three provisions is proved for the maintenance. Then this is the interim maintenance. While the pendency of the petition, the magistrate may order to the respondent for the interim maintenance. So during the pendency of proceeding regarding monthly allowances for the maintenance under this provision, the magistrate may order such person to make a monthly allowances for the interim maintenance of his wife or such child, father or mother, and the expenses of such proceeding which the magistrate consider reasonable, and to pay the same to such person as the magistrate may from time to time direct. And an application for the monthly allowances for the interim maintenance and expenses shall, as far as possible, be disposed of within 60 days from the date of the service of notice of the application to such person. These provision is regarding to the interim maintenance. When the person is unable to maintain himself, how can he continue in the proceeding when he has no any earning? Then this provision has been laid down in the criminal procedure code. During the pendency of proceeding, the respondent may be compelled to provide interim maintenance to the petitioner. That means when we discuss about the Hindu law, then both party may file a complaint for the interim maintenance. during the pendency of the divorce petition, during the pendency of the separation petition, during the pendency of the conjugal of right petition, both parties may claim for the interim petition, interim maintenance. But in this provision, only this rights is given to the petitioner, because the petitioner is unable to maintain himself. Then the petitioner is having the right that he can claim for the interim maintenance against the respondent. Then two terms has been defined. Who is the minor? Minors means that person who has not attained the age of the majority, and wife means includes a wife who has been divorced by or has obtained a divorce from her husband and has not remarried. That means the wife is entitled to get the maintenance from her husband, who either he has divorced wife, he has given the divorce, or he has been given the divorce by her husband. Both are covered in this provision, but one barrier is there: she does not remarried. If the wife got remarried, then she is unable to get the maintenance under the criminal procedure code. Now the question is that what are the date from which the maintenance order may be enforceable? So any such allowances for the maintenance or interim maintenance and expenses for the proceedings shall be payable from the date of the order, or if so order, from the date of the application. This is depend upon the magistrate, that he may order the maintenance may be payable from the date of the order or from the date of the filing of the application. This is discretionary power given to the magistrate. Where the order has been given by the magistrate against the respondent is responsible to make the payment, make the maintenance to the petitioner, but respondent does not follow the order of the magistrate. He is not executing the order of the magistrate, he is not making the payment to the petitioner. Then this provision is given. If person does not provide maintenance after the order, if any person so ordered fails without sufficient cause to comply with the order, that means if that person, if the respondent is having the sufficient reason that why is not paying the maintenance to her wife, then this provision will not be applicable. Only this provision is applicable when the respondent is not maintained to her wife after giving the order by the magistrate and he is not having sufficient reason. Then any such magistrate may, for every breach of the order, issue a warrant for levying the amount due in the manner provided for levying fine. And after the execution of warrant, allowances is remaining unpaid, and court may pass sentence to such person to imprisonment for a term which may extend to 1 month or until payment. These are the provisions. If the person fails to maintain the petitioner, the magistrate may issue the arrest warrant and proceed to that person to jail. And that imprisonment, that confinement, that detention may be for 1 month for each failure or until the allowances paid. This is the discretion given to the magistrate, and such sentence may be for the whole or any part of each month's allowances, and such sentence may be for due allowances for maintenance or other things and expenses for proceeding as the case may be. So that means this power is given to the magistrate, that he can make compel to the respondent, and thereby the respondent uh, may be bound to provide the maintenance to the petitioner. So what are the allowances are remaining? For that allowances, the magistrate may issue the arrest warrant and compel to the petitioner to compel to the respondent to provide the maintenance to the petitioner. And when the warrant shall not be issued, no warrant shall be issued for the recovery of any amount due under this provision. when an application is made to the court to levy such amount which are due since more than 1 year. That means the respondent may only be bound to provide the maintenance only for the 12 month, not for more than 12 month. If the maintenance are due more than 12 month, that the magistrate cannot issue the arrest warrant and cannot compel to the respondent. And when wife is entitled to get maintenance, this provision is only given to the this provision is regarding only to the wife. No doubt, son, wife, and parents, these person are the entitled to get the maintenance under 125. But here we are discussing about the wife. When wife is entitled to get maintenance, she is not living with her husband due to any justifiable ground. These are the first ground. That means when the wife is having reasonable cause, justifiable ground that she is not living with her husband, then she is entitled to get the maintenance. And if husband offers to maintain his wife on condition of her living with him and wife refuses to live with him on any ground, and magistrate may consider that such ground of refusal is justifiable, and then the magistrate may pass an order for the maintenance. That means if the wife is not living with her husband, then she is also entitled to get the maintenance from husband, but the ground must be justifiable. There are few examples. What are the justifiable ground when the wife should not live with husband? What is that? Contracted marriage with another woman and keeps a mistress. These are the sufficient ground. Apart from these, the cruelty is also, the demand of the dowry is also a justifiable ground. It was declared by the court, and it shall be considered to be just ground for his wife's refusal to live with him, and then wife can call for the maintenance. And when wife is not entitled to get maintenance, vice versa, no wife shall be entitled to receive an allowances for the maintenance or the interim maintenance and expenses of proceeding, as the case may be, from her husband under this provision if she is living in adultery. These are the provisions. And or she refuses to live with her husband without any sufficient reason, or they are living separately by mutual consent. One more provision is attacking there, that the adultery has been declared as an unconstitutional by the Supreme Court, but that adultery is differ from this. When the wife did the cohabitation with any another person, this is amount to adultery, and husband is not entitled, not husband cannot be made bound to maintain his wife. So then the wife is living in adultery, or she is refuses to live with her husband without any sufficient reason, or they are living separately by mutual consent. These are the three grounds where the husband is not bound to make the maintenance to his wife. Then wife is also not entitled to get the maintenance. He cannot file a petition. If file a petition, petition may be dismissed by the magistrate. And when the maintenance order may be cancelled, the magistrate shall cancel the order when it is proved that wife is living in adultery. This provision is given after the order passed by the magistrate to maintain his wife. Once the order has been passed by the magistrate for the maintenance, then after this fact has been proved by the respondent, what is that wife is living in adultery, or why without sufficient reasons she refuses to live with her husband, or they are living separately by mutual consent, then after the magistrate um, may withdraw their maintenance order. So once the order has been passed, then the subclause 5 of 125 is applicable over there, where the respondent has to prove these are the three ground. Then the magistrate can cancel their order already passed. Now we are discuss regarding the procedure. What are the procedure may be followed by the court? So these are classified into two categories. First of all, the place of proceeding, and second is the procedure of summon trial. So what is the appropriate place where the petition may be filed by the petitioner? First of all, where respondent reside. This is the appropriate place for the filing of the petition. Where the petitioner is the child, where the petitioner is the parents, and where the petitioner is the wife. They can file a petition where the second party against whom he is going to file a petition, where second person is residing. And second is that this is second option is given only to the wife, where respondent or his wife resides. So where the wife is petitioner, then the petitioner, then such wife may file a petition in that court where the husband resides, that means respondent resides, or she is wife, then that means where she is resides. She is residing, or where respondent last resided with his wife. This is also appropriate place for filing the petition. That means where is the matrimonial home of that pair, that spouse, that is also the appropriate place. That means if the wife is going to file a petition and where is the matrimonial home and she is also living that matrimonial home, that means he can file a court who is having the local authorities over that area, or the case, or as the case may be with the mother of illegitimate child. If the petitioner is the child, this is the illegitimate child, and where that illegitimate child's mother is living, that court who is having the authorities over that area, this is also the appropriate place. For the example, A is the illegitimate child living in Dehradun with his mother, and the parents and the father is living in Haridwar. That means that illegitimate child is having the right, he may move to file a petition for the Haridwar court or the Dehradun court, because his mother is living at Dehradun. Then procedure of summon trial, but this right is not given to every person. Where the parents is going to file a petition against his children, then where the children reside, this is the appropriate place for the parents. But for the wife, where the wife residing, where the husband residing, both is the appropriate place. And in the case of the illegitimate child, where the mother residing and where the father residing. But parents, where the respondent residing, and legitimate child where the respondent residing, that would be the appropriate place. And procedure for summon trial may be followed by the proceeding court, that means the magistrate first class. All evidence to such proceedings shall be taken in the presence of the person against whom an order for payment of maintenance is proposed to be made. And if respondent exempted from personal appearance, evidence shall be taken in the presence of his pleader and shall be recorded in the manner prescribed for the summon case. And when the petition has been filed by the petitioner and the summon has been issued by the magistrate, but the respondent is willfully avoiding service of summon, or the respondent is willfully neglecting to attend the court, then the magistrate may proceed to hear and determine the case ex parte, and the magistrate may pass ex parte decision. This is a right given to the magistrate. And when the ex parte decision has been passed, and then after the respondent come aware about the decision that the against him order of maintenance has been passed, then they may appear before the court within 3 months, and his application show good cause that why he had not appeared before court. Then the magistrate may set aside such ex parte decision, and if he thinks cause is just and proper, what is the shown by the respondent in their application. And but the magistrate is also given the power that he can impose the fine and as a cost, and that fine may be given to the petitioner. And the court in dealing with application under 125 shall have the power to make any other cost, to make an order to provide the cost as may be just and proper. So these are the power given to the magistrate, that he may pass ex parte decision if the respondent is not aware, even the serving of the summon. And then if the respondent afterward appears before the court, that ex parte decision may be set aside by the court and fresh proceeding may be started. And 125, that means alteration in allowances. This provision come into the picture when once the order has been passed by the magistrate for the maintenance. Then after the circumstances has been changed, either in the side of the petitioner or on the side of the respondent. So when the respondent proved that circumstances has been changed as such that the maintenance should not be provided under provision 125, or it should be altered. These are the provisions under which the petitioner is not entitled to get the maintenance. That is the circumstances arising. Or some changes is also there where the amount of the maintenance should be altered, reduced, like that, reduced. Then the magistrate may make such alteration as he think fit, and in the allowances for the maintenance or in the interim maintenance as the case may be. Suppose that the respondent proved that the wife is living in adultery, that means she is not entitled to get the maintenance, then the magistrate may revoke their order under this provision. Or second is that if the wife started earning, then this is provision is also over there where the magistrate may reduce the maintenance amount. Where any civil court has also passed maintenance, where it appears to the magistrate that in consequences of any decision of the competent civil court, petitioner is receiving some maintenance, the maintenance shall cancel, magistrate shall cancel the order, or as the case may be, vary the amount of maintenance accordingly. That means where the petitioner is has filed the civil suit and also getting some maintenance from the civil court, that means up to such amount the magistrate may reduce the maintenance amount, or he may revoke their order. This is depend upon the magistrate. And when the court may cancel his maintenance order, where the maintenance order has been made in favor of the divorced women, and the magistrate shall cancel the maintenance order if he is satisfied that that divorced lady got the remarriage. And second is that received customary maintenance from their husband. These are the two conditions when the court may cancel his maintenance order. And then after we will discuss the case laws in their next lecture. But something is also there that magistrate can cancel his maintenance order. That means if the court has already ordered for the maintenance and wife receive customary amount uh, customary amount after the order, then the court will quash the order from the date of its order. And whether the husband is ordered to maintain for time being, court may cancel his order from the date of expiry of that day. This provision is also very important for that, where the respondent has been ordered to pay the maintenance for the time being only, like that dependency of the litigation. So when the matter has been resolved, that means the time has been expired, and then the magistrate can cancel their order to maintain the wife. And this is the C provision is that voluntarily surrendered her right, when the wife or when the parents or when the child has surrendered their right to get the maintenance from the opposite party, then the magistrate can also cancel their order. and at the time of making any decree for the recovery of any maintenance or dowry by any person to whom a monthly allowances for the maintenance and interim maintenance or any of them has been ordered to be paid under provision 125, and the civil court shall take into account the sum which has been paid to or received by such person as monthly allowances for the maintenance and interim maintenance or any of them as the case may be in pursuance of the said order. These are the provisions for the maintenance given over there. And 128 is the last provision, enforcement of the order of maintenance. The copy of order, that means a copy of the order of maintenance or interim maintenance and expenses of proceeding as the case may be shall be given without payment to the person to whose favor it is made. That means if the wife win, the order of the copy of the order may be given to free of cost the wife, and if the respondent win, then one copy should be given to that person free of cost, or his guardian if any, or the person to whom the allowances for the maintenance or the allowances for the interim maintenance or expenses of the proceeding as the case may be is to be paid. And enforcement, such order may be enforced by any magistrate in any place where the person against whom it is made maybe, or on such person being satisfied as to the identify of the parties and the non-payment of allowances or as the case may be expenses due. So that means who is the competent magistrate for the enforcement, then where the person residing against whom the order has been passed, that magistrate is empowered to for the enforcement of that order under which authorities that person is residing. So that means this is the provision of the maintenance, and these are the case laws. This is very important case laws, and the this is year wise. You should remember this case laws. Muhammad Ahmad Khan versus Mano Begum, Muslim Women Act. This was passed by the Rajiv Gandhi government, and Dr. Mrs. Vijaya Manohar Harbat. And this case we will discuss in there our next lecture. Thank you. Have a good day.